Ms. Brace, have you reviewed the Supreme Court's definition of the phrase hatred in advance of drafting Bill C-9? Yes or no?
Yes.
The Supreme Court's definition of hatred includes the words emotion of an intense and extreme nature. Why have you dropped those words from your proposed definition of Bill C-9?
Thank you for the question. The definition reflects or captures the body of Supreme Court of Canada jurisprudence on the definition of hatred. The extreme and intense description is captured by the words vilification and detestation, as the Minister had pointed out earlier. It is also clear that it is stronger than disdain and dislike. And so the definition, the intent is to capture the Supreme Court of Canada's jurisdiction by indicating the high threshold of what is hatred and the narrow scope of it.
I don't agree with you that you can have a disdain or dislike that's not necessarily extreme in nature or not intense in nature. And I also note that the definition is conjunctive. It's both intense and extreme, something that the Supreme Court has clearly articulated and is still good case law today. Were you instructed by the Minister or any political staff to drop the words intense and extreme nature from the definition?
MP Bathurst, so thank you for the question. We want to be very clear on what the government's perspective is, and certainly,
please go ahead.
Have heard the concerns that you've expressed.
The question was: Have you been instructed by the Minister or any of his staff to drop the words intense and extreme nature from the definition?
No, and the government's position in what it is advancing in the definition is intended to reflect the Supreme Court jurisprudence. That is what we are seeking to do.
You can have an intense and extreme nature for a positive emotion. You could be happy in a very intense and extreme nature. You could love a loved one intensely. So I would not necessarily say that just because you use two different words, such as disdain, that you necessarily meet the high threshold articulated by the Supreme Court. I'd like to go back to your point, Mr. Ripley, with respect to the screening process in private prosecutions. I agree with you. Yes, you would have a pre-enquête hearing where a judicial officer, a magistrate, or a justice of the peace would either green light process to issue on private prosecutions or not. However, in almost all cases, the informant, so the complainant, would have an ability to appeal that decision to judicial review and take that to divisional court. And the accused is typically a party or an invited party to such a proceeding. And so even though there may be no cause for criminal charges to be instigated, the alleged accused would be dragged before the divisional court, would have to incur legal fees, would have to suffer reputational risks, time inconvenience, to be accused of a criminal charge. Don't you see how this potentially opens itself up to abuse, to ruin the lives of ordinary Canadians who should not be before a criminal court?
So, thank you for the question, MP Baber. As we've highlighted, there are mechanisms to safeguard those frivolous private prosecutions. Acknowledge that they can, in that kind of situation, it can still have an impact on the accused. And I think you heard the minister. I think you heard the minister express an openness to hearing the committee's views on that point.
So you understand that there's no safeguard against the appeal of the pieces of justice decision appeal to judicial review in divisional court. There's no safeguard for that, sir.
I hear what you are saying, that if an individual accused finds themselves in that position, that yes, there is an impact for that person.
Thank you.